Good morning. Good morning. How are you? Let me get this my earbuds connected, and away we'll go. So this morning is connected. I think it is connected. Yeah, it is. Okay. All right. Good. There. This morning, March the 3rd, and today is a Supreme Court live hearing day. So today I thought we would just go over to the Supreme Court and just do a little watching of the live court in action and hear what's going on out there. Today's cases are not criminal; they're civil. But they are also important in the state of Texas, um, and how we look at people and things, and just come watch with me. We're also going to talk about some other things that are very upsetting. Number one being the shootings that happened in Texas down on 6th Street. Many UT students are injured. A few people lives were taken in the name of Allah, I guess. There's a 53-year-old man, which was he had a T-shirt on that said something. I don't want to be negative, derogatory, or anything else, but I will say it was unnecessary, uncalled for. And as a mom of a student at UT in Austin, it scares the shit out of me to think that my child can't even go across the street to one of the little local areas from where he lives, because he lives down there off of 26th Street, and have a good evening without the fear of somebody driving across the street, toting a gun, just shooting just shooting at anybody walking by, or going into the establishment, just opening fire on people who thought they were just there to have a little Saturday evening, just minding their own damn business, not bothering anybody. And then you got a cuckoo, crazy ass, yeah, I said it, going in there and doing that kind of stuff. So anyway, let's get going this morning with our Texas Supreme Court. But the story I'm talking about is actually, let me pull it up. Oh my goodness. Let me pull this up for you right quick. We'll just go over here to we'll just go to YouTube and pull it up. Why not? It's all over YouTube. Let's see. It's shootings in Texas, 6th Street shootings. Okay, it is a terrible situation. Oh, I didn't mean to pull her up. Hang on, sorry. Thank you, Pink Chihuahua. We always love you, but that's not what we're talking about this morning. Okay. This is from 2 days ago, and this is from Live Fox 7. Here we go. Well, actually, we're going to watch Fox 7, the gunman identified. Here we go. Let me get my StreamYard. Let me share the screen real quick. This is horrible. It is really horrible, and I feel so sad for the. You send your children over here to go to school, and you don't expect these kind of things to happen. But quickly, we're going to watch this quickly. So let me make this big, and it's going to be, of course, full credit to Fox 7 Austin. Here we go.
Of terrorism in Austin overnight. Good evening, and thank you for joining us. I'm Alec Nolan. The FBI is investigating a mass shooting on 6th Street as a potential act of terror. At least 3 people are dead and more than a dozen injured. Today, we're bringing you team coverage with live updates as they come in. We want to get right to Fox 7's Marco Bittnell, who is outside a home tied to the suspect in Austin's mass shooting. Marco, what's the latest?
Well, Alec, we're slowly starting to have more details on the man potentially behind this deadly shooting in Austin. Right now, we're outside a home linked to that suspect in Pflugerville. You can see it right behind me right now. That is the home right there where that white car is parked in front of. And this home has been the focus of some very heavy law enforcement activity throughout the day. I want to start off by showing you a picture of the suspect. This is 53-year-old Ngiaga Johnny. You can see him with an AR-style weapon in his hand, wearing a hoodie early this morning, which says property of Allah, with it being reported that he was also wearing a shirt with an Iranian flag on it. He was killed by APD after supposedly opening fire on West Street around 2 this morning, killing and injuring several people. Johnny was a 53-year-old from Senegal, but has been a naturalized citizen since 2013. Today, this home in Pflugerville linked to him was at the focus for law enforcement, as we saw local police and ATF agents bringing out boxes of what appeared to be evidence from the home. That was after neighbors tell us that SWAT units carried out a search warrant around 11 a.m. today at the house. Just go ahead and take a listen to a nearby resident who recalls the moments he found out what was happening.
It's sad. It's really sad.
I got a call and a picture from one of my neighbors with a little bomb robot walking through my front yard, and I thought they were at my house. So I rushed home as quick as I could to come to find out SWAT was executing a search warrant across the street. They were on a loudspeaker talking to whoever was inside, saying, "Hey, come out with your hands up. We have a search warrant. Come out with your hands up and empty," and this kind of thing. They were really patient. It was about an hour that they waited. And then just after noon or so, they went ahead and breached the house. You could see the SWAT guys approach the house.
For fair use, we have to stop every once in a while. But can you imagine you're at work, you notice that your cameras around your house, you're getting a little sensor on your phone that something's going on. You open your phone, you look at, and there is something going on in your neighborhood, and it's pretty big. And this neighbor had no idea that his neighbor, or the neighbor across the street from him, was actually the gunman that opened fire on the kids in Austin downtown this weekend. So this was quite a rude awakening for this poor guy. And I can imagine how he would feel knowing that he's living next to this and didn't even know it. Here we go. We'll continue watching this story, and then we're going to move on to the Texas Supreme Court.
House.
The scene was cleared by law enforcement a few hours ago, but since then we have seen a decent amount of activity from people inside and outside the home, coming and going. It's unclear if they're friends or family members of the suspect. It was just less than 10 minutes ago that we saw about 4 of them leaving the home, getting into a few of these vehicles and leaving. We tried to talk to some of them, but they denied to have any comment. We'll continue to bring you more updates from here in Pflugerville, but for now, reporting outside Pflugerville, Marco Beno, Fox 7 Austin News.
All right, so now, the next thing we're going to go to is I just wanted to talk about that for just a second because it is heartbreaking. And, prayers out to the families, and to the students, and to everybody that had this happen to them. Again, it's such a serious and sad situation. It should never happen. It should just never happen. Now, the next thing we're going to do is we're going to go ahead and we're going to pull up the Supreme Court of Texas. This morning, they're having their live hearings. And let me tell you what their hearings are about this morning. So I'll pull this up. Okay, hang on. Okay. Live hearings. Pull this up on my iPad so we can talk about it real quick. Supreme Court, Texas. Okay. Come on, let's go, little iPad. Sometimes it works so slow. So we're going to watch the oral arguments this morning that are currently happening in Texas at the Supreme Court. Now, it starts at 9 o'clock in the morning, which I'm letting them get started before we start watching. So let me get the calendar and pull it up, what we're going to watch this morning. Okay. Oh, well. Every time you log in or sign up or whatever, it does these weird, like you got to agree to this, agree to that. So let's see. So today's hearings are, hope everybody had a wonderful evening. I can't believe it's March 3rd already. It's like, where is the year going to? Okay. Here comes the calendar. Okay. Oh my goodness. As soon as you want to pull something up, you can never find it. That's how it goes here. Texas Supreme Court calendar, and it's right here. Let's go. Now, this morning, we are having oral arguments from 9 to 12. It's 9 a.m. to 12 p.m. And the first case is 24-0924 MV Transports Incorporated versus GDS Transports Incorporated. This case is going to be about limits to damages of liability of regional transportation authorities, independent contractors that performs a function of the authority to the extent of the authority's liability. MV Transportation argues that this statute grants its complete immunity from liability for alleged fraud under the facts of this case. Whoa, fraud. Hey, Cinderella, good to see you this morning. How you doing? Did you watch, Cinderella, did you watch this situation with Jack and Lily yesterday? And the fact, that he went to court over his other charges. But no, nobody's looking at him over the disappearance of Jack and Lily. I don't want to see clickbait. I don't want to see none of that. Let me pull this court up. Because they put it, when people put that kind of stuff out there, you think, oh boy, there's movement, something's happening. No, No, nothing's happening in that case. It's so sad. And I'm so sick of seeing these kind of things. One of the things that upsets me about that case is the fact that Malaya put her kids there and she's over there taking no responsibility for what happened to them. She just walked away. Anyway, that's enough about her. She makes me sick. All right, here we go. Now, this is going to be the official Texas Supreme Court of Texas. And they have this that starts at 9 o'clock this morning. So that's 3-5. We're over here on 3-4, 3-2, or 3-3. So we're starting right now. Isn't today the 3rd? It is today. It's March the 3rd. And it should be starting at 9 a.m. So any minute now, this should be going. Chat, let's see. Subscribe, let's see what's going on. Okay. Chat is disabled on this live stream. Okay, that's fine. Okay, so here we go. We're just waiting on this to start. I guess it'll start in a few minutes. Let me see if I can. Yeah, let me see why it's not started. It is 9 o'clock already here. So let me get back over here to you. Okay, so let me share my screen so when it starts, we can get started on it. Here we go. Oops, got to share your screen, silly girl, silly girl. There we go. And there's is the courts. And there we are. So when it starts, we can start watching it. It should be it's supposed to start at 9 o'clock, but it's already 9:10. They could be running a few minutes late. I'm not sure, but we'll just wait and see. We'll just give it a few minutes. But anyway, no, you didn't watch it. Okay. Well, and I don't mean to be upset and griping. That's really, and what my point I'm trying to make is clickbait. We should not be seeing clickbait on any of these missing children's cases. Because when you start putting that clickbait out there, just like it gets us excited, well, the members of those families get excited too because they think, oh boy, we're going to hear something, right? And I know it's on YouTube, and people are like, well, it's just YouTube. But sadly, and in the reality, a lot of the things we do see on YouTube directly coordinate with what's going on in the real world because they're getting information from a news station. Some of these people do have enough clout to get information from a news station. It's not all just their opinions or whatever, that kind of thing. So anyway, I just want to talk about that for a second. But yeah, we'll be ready for the Supreme Court to start soon. Another thing we're going to start talking about soon is I'm looking for my next case. I'm looking for my next case to go and talk about where we've had an appeal and they've had the hearing. I watch every day to see if Letitia Stouch's case has been confirmed or if she's getting a new trial. Nothing's come up yet, but it could take months. Like there's no set time for them to give after oral arguments for them to give their opinions. So it could be 3 months, it could be 4 months, it could be 30 days. We just don't know. But there's a lot of cases out there that have already had oral arguments. I mean, your capital murder cases, their oral arguments, it takes about a longer amount of time to get to the Supreme Court. But if it's just kind of they were found guilty and they got life in prison without parole, those kind of cases get into the Supreme Court much faster than a capital murder case, which I know that sounds weird because it should go as their file, but it really doesn't work that way. So let's see which case we want to go with next while we wait on this. There's 3 cases on the court docket today. The second court case is 24-1033. It's Fasken Oil versus PUIG. I guess it's Pew from Webb County and the 4th County Court of Appeals. In that case, the parties dispute the method for calculating the value of oil and gas minerals upon which to pay a royalty. The royalty reserves an undivided 1/16 of all oil and gas and other minerals except coal into and under in that may be produced from the above described acreage to be paid or delivered to grantor B.A. I'm sorry, his name is B.A. Pugh Jr. Okay. As his own property, free of cost forever. Fasken operates wells through relevant leaseholds in paying the royalty owed. Fasken deducted costs incurred after production to arrive at the market value of the minerals produced at the wellhead. Here's the deal. In that case, there is a lease. In case you don't know anything about this, I'll just we'll just talk about it for a minute. But the way they drill wells and the way they pay the production, royalties to the people is based on a lease. They always have a lease on these wells. Now, if it's a horizontal well, it's different than if it is which most wells that have been drilled in the past, 10, 12, 15 years or horizontal wells, or even 20 years horizontal wells. So that's just a little different, because in order to drill a horizontal oil well, you have to have 160 acres. So what they do is they go out and they find people that own all this land, and then they divide this by however many owners there are, plus the business that's going to actually be the drilling, who owns the well, the drilling, and all that. So it's pretty interesting. I've always been interested in oil and oil wells, and how it comes out of the ground and how the whole thing works. My first husband worked for an oil company, but anyway. That's one of the cases this morning. And the third case that's going to happen today is called 24-1070, which is River Creek Development Corp. Versus Preston Hollow Cap LLC. The principal issues in this case are whether a certain public financing agreements are void because they were not submitted to the Attorney General for approval under Chapter 431 of the Transportation Code, and whether the agreements comply with the Public Improvement District Act. So that's what's going to happen this morning in the Supreme Court, if they will ever start the oral arguments. It says 9 a.m. It is now 9:15 a.m. So I'm not sure why we don't see anything, but we'll just talk for a few minutes and let them get started. Let me see what other cases on the dockets this week. There's another. They're going to have court today, tomorrow, and Friday, I believe. Let me look at this calendar. I'll tell you how many days they're going to have court this week. But I mean, people don't realize how many cases actually get oral arguments versus how many cases are filed. Okay, so tomorrow there's going to be oral arguments again from 9 a.m. to 12 p.m. and it's going to be Gopalan versus Marsh, Champion Food Service Incorporated versus Pro Alamo Foods LLC, and in regards to Home Depot USA Incorporated. So that's going to be that. And then the next set of cases that's going to happen on Thursday, come on, let's open it up, is on Thursday. On Thursday we might have to come back and watch. Texas General Land Offices versus Sage RGB, consolidated for oral arguments. Cameron County versus Sage RGB, and Paxton. Paxton versus Sage RGB. From Cameron County and the 13th Court of Appeals. That issue is whether a citizens group may challenge a status authorizing the closure of a public beach as unconstitutional. Well, that's going to be a good one to watch. The other one that's going to happen is the state versus the city of McAllen. From Travis County and the 3rd Court of Appeals, an issue in this case is whether the Senate Bill 1004 and Senate Bill 1152 are unconstitutional under the Texas Constitution's gift clauses. Now, that might be interesting as well. Then on Friday in the Texas Supreme Court, they're going to order their issues from past cases. Now, when they order issues, let me see which ones. Oh, it doesn't tell me which ones are going to be issued, so that I can't answer that. But let me see if there's any. So the only oral arguments they're going to have so far this month are Tuesday, March the 3rd, Wednesday, March the 4th, and Thursday, March the 5th. Okay, and then they're going to do a court conference on the 24th. Let me see if we can see what that's about. No, it's not showing. It's not telling us. And then every Friday they order the issues. They issue the orders from past Supreme Court hearings. So let's see what's going to happen next month, because I'm trying to watch all the Texas. Oh, they don't have them listed yet. Okay. All the Texas capital murder cases that have went to appeal, so that we can track them, watch them, and see what the final agreements are. Okay, let's see. Let's see what happened in okay. Nope. Go back one more month. We're going back to the follow-up with the month before to see if any of the oral arguments were things that we want to look at as far as Texas Supreme Court and death penalties. Paxton. Well, not very many, right? I mean, there's a lot of them that they see them, they discuss them, but they just don't have oral arguments. Like they can have arguments without it being shown on TV. They can just do it without it being oral. So, which is interesting. Let's see. No, let me go back one more time. I'm looking on last month to see if there was anything worth looking at. Let's see. Go back. I don't see anything. April. Let's go back to January and see if there was anything of issue worth looking at. Let's see. They did Texas Department of State Health Services versus Sky Marketing, Weldon versus Lilith. Okay. And nothing. So far, nothing this year. Well, Texas Department of Public Safety versus Callaway. That's not. See, they don't really have the criminal oral arguments very often, do they? Okay, Clifton, KK. Okay, I'm looking to see if there's anything over here we might want to pull up and watch while we wait, because apparently they're running late, which is weird to me that the Supreme Court would be running late. Okay. Okay, Carter versus Minton. Yeah, nothing yet. Okay, let me go check their live feed over here. Hang on a second, guys. I know it should be started already. Let's see what's going on here. Well, I'll tell you what we're going to do. While we wait on them to get started, because apparently they are not started yet, we will go and watch. Hang on a minute. We'll go watch. Let's watch something else real quick. We talked about this case yesterday. Let's talk about Burgos Aviles from yesterday. Damn it! I wish they would start already. I feel stupid now because they are not starting, and I'm over here waiting. Let's watch. We'll go watch a little bit of this Mr. Burgos Aviles. You know, hang on just a second. Let's watch a little bit of this.
At times you can see that
now, this is going to be just Mr. Burgos Aviles.
He's trying to clean off. It looks like he's trying to wipe
his actual interview.
His arms. Trying to wipe his arms, both arms, and then he gets underneath his t-shirt, starts kind of rub his t-shirt.
Yeah,
I guess we'll see it here. I'm not sure if he
evidence.
licks his hands with saliva, but he is rubbing, trying to rub things off his arm and his chest specifically. And then he's talking to himself, or he whispers, says things.
Yeah, he's a real piece of shit. Yeah, I'm saying it.
At times you can see that he's trying to clean off. It looks like he's trying to wipe his arms, both arms, and then he gets underneath his t-shirt, starts kind of
we'll go
rub
find
his
some more to watch
t-shirt.
while we wait on the court to get started. I don't know why. I don't know if they're gonna. It's okay. We'll just work through it. It's fine. Watch this one.
Right. As the Border Patrol, they're supposed to protect
we'll
and they're supposed to serve our country and help people. So the idea that someone would do something like this is horrific. But we also have to remember that no one is above the law in our country. But the prosecutor has to prove every single element of the cause of action. And they told a very, very compelling story.
Pretty good witness, this sister, Kelly.
Yes, very compelling.
All right, let's find a little bit longer one, not a short. Oh, let's watch this right here. Now, this is the motion for the mistrial that he denied. Okay. I'm going to keep checking this.
If your motion is for a mistrial, your motion is denied.
Just quick and simple. You're denied.
If your motion is for a mistrial, your motion is denied.
Yeah, of course. Let's see. Watch this for just a second.
If you followed the Ronald Anthony Burgos Aviles trial with me, then here's an update for you. The former U.S. Border Patrol agent turned murderer is now asking for a new trial. Of course, this is standard legal procedure. We thought that he would do this, and he has. I really hope that the judge gives him that classic, that smile, and just like, your motion is denied. And in case you missed this, on August 25th of 2023, they said 400 inmates must be transferred to other Texas facilities after a fire at Huntsville prison broke out. I'm not sure if Burgos was part of that or not. I didn't see the transfer link or anything for him. Let me know if you know. If you have local knowledge, let me know. But he may have actually been transferred to another prison. Thinking of Griselda and Dominic Hernandez's family. The justice has been served. And if there's going to be another trial, it's going to be served again. We'll be there for it, right? If you don't know anything about this case, on Grizzly True Crime on YouTube,
but
I'm going to link the playlist up here for you. There's summary videos and the full trial for you to catch up.
Yeah. The appeals court has made its decision. Let's watch this for just a few minutes while we wait on the court to get started. I'm checking this calendar to see if they've started yet. Y'all bear with me. I'm so sorry, guys. I mean, who would have thought that the Supreme Court would run late?
That he proudly served his country.
Oh, that's low.
Military records where he didn't cause trouble. He didn't, he had a perfectly normal record, no violence, nothing. He's still a father.
It's 9:20. It's almost 9:30. The shit started already. This is craziness. Let's go back and we'll see if we can't. Listen to this part though. This is him. You know, this was this asshole.
I don't.
Thought it was okay for him to take the life of that woman and the child. He didn't want to have to admit what he did. It's machoism. You're right.
You a citizen there, bro?
Yeah.
Yeah. Where you from?
I don't answer no questions.
Huh?
I don't answer no personal questions.
Where you from?
I don't answer personal questions.
It's not a personal question. It's a citizen.
Where are you
citizenship
from?
question. Huh?
Where are you from?
Oh, are you an agent now? You want my badge too?
Where are you from?
You want my badge?
You're
too?
asking me where I'm from. Where are you from?
Go
Wow.
ahead, find number 2 over there. Second.
No, sir. We're not going to stop in secondary. We need to get on our way. We need to keep going.
Damn.
We're in a hurry to get home.
Look at that beautiful baby. Makes me so sad. Who does he think he is?
I
You
don't.
know? Who does he think
You a
he is?
citizen?
All right,
Anybody
let's
here in the back?
All right,
In the
yeah.
back? You know the window?
All right. Okay.
You a citizen there, bro?
Yeah.
Yeah. Where you from?
I don't answer no questions.
Huh?
I don't answer no.
Okay, have they started yet? Come on. Okay. Yep, it's not showing it yet. I don't know why. 42 of us waiting for it to start this morning. Yeah, let's get going. So we'll just kind of read some of this right here while we wait, because what I do have in front of me is for the Supreme Court, the briefs and all that. For the first case, the oral argument submission from the attorneys that were received, and we'll look at that really quick. So the attorneys, the associated, let's see, we have Marcos Ranguelio, Stephen R. Shaver, and Julia F. Pindery. And for the associates are Stacy Oberhaus, Aaron Etchapel, and Robert Slobeck. And the case contacts are Barbara Hodges, Tanya Durham, Belinda Rodelio, and Kristen Hernandez. So this is the automated certificate of service for this case on behalf of Stacy Oberhaus. Okay, and this is our first case that we're going to hear today is 24-0924. Okay, now, oops, no, don't do that. So let's look and see if the brief is right here. There's the oral arguments, there's the petition, there's the replay. Okay, here's the reply brief on this case as we wait for it to start. You go up here and find it. GDS concedes or fails to dispute material matters. GDS Transport LLC's sole challenge is that MB Transportation was not performing a function of DART when MB engaged in the conduct alleged. Thus, MB's acts fall outside of the statute scope, i.e., that an independent contractor of a regional public transit authority that performs a function of authority is liable for damages only to the extent that the authority would be liable if the authority itself were performing the function. And then it gives a bunch of citings on this, right? So the DART has governmental immunity from intentional tort claims such as the fraud claim GDS asserts in this case. The MB Transportation's liability is limited to zero if this court holds that MB is performing the actions that form the basis of GD's claims, was thereby performing a function of DART at the time. That the alleged fraud occurred in the course of MB Transportation's negotiations with GDS for contract to provide paratransit and microtransit services for DART REST under brief -79. That providing these transit services was a function of DART, and then it gives the Texas Code transportation codes. These concessions are fatal to GDS's position in this matter. MB Transports was performing a function of DART. GDS argues that MB Transportation, in negotiating with GDS to sign a subcontract to operate DART's paratransit, microtransit services, was not performing this function of DART within the meaning of the Texas Government Code. Specifically, GDS argues that committing fraud while managing these DART transportation services is not a DART function. Well, no, committing fraud is never a function of somebody. Oh, wow. I can't believe they put that. Okay, we'll just keep reading because I can't believe they had to even state that, really. Okay. Making fraudulent misrepresentations to induce a subcontractor to give unrealistically low prices in a proposal is not a part of managing operations that DART, Microtransit, or Paratransit functions. Yet, as MV Transport has explained, the issue is MV's actual conduct, not whether the conduct would be construed as the breach of legal duty. And it gives the C brief number, blah. I'm not going to read those. Because it depends on an analysis of the function performed, not simply the characterization of the claim. This matter would be different if GDS accused MV Transportation of defrauding GDS into purchasing canola. This is over canola oil? Are you kidding me? All right. Let me start over right there. This matter would be different if GDS accused MV Transportation of defrauding GDS into purchasing canola oil futures or a subscription to Teen Vogue, selling financial instruments online. This is wild. Selling financial instruments or online news features is certainly not a part of the DART function. This view of this matter is consistent with the dictionary definition of function, the kind of action or activity proper to a person, thing, or institution, the purpose for which something is designed or exists. And then it goes the role, function, Random House Unabridged Dictionary. There is no dispute in the present case that MV Transportation at all pertinent times was acting within the scope of the efforts to operate and manage for DART some public transportation services that was DART's purpose and role. GDS then pivots and insists that the statute only applies when the contractor is performing the functions for the authority, not just when the contractor is performing any function of the authority that could perform under its own authority. I know it's a lot of mumbo jumbo here. Lots of word salad to come up to make a point, I know. Okay. Okay, yes, as MV Transportation has explained, the statute gave DART authority to develop, plan, own, operate, and maintain a public transportation system, to contract for the operation of all or part of the public transportation system, to delegate, to designate persons to power of contract for these services. And it cites Texas transportation codes, and to effect that the authority, the statute also gave DART any power necessary or convenient to carry out this chapter or to effect a purpose of this chapter. GDS is simply wrong about the statute. It expressly did not grant DART the power to take unenumerated action needed to exercise these express powers, like negotiating for contracts to provide public transportation services within its statutory mandate. The authority as legislature granted includes the authority implicit in the actual authority of an agent. An agent has actual authority to take action, designated or implied, and the principles manifestations that the agent enacts necessary or incidental to achieving the principal's objectives, as the agent reasonably understands that the principal's manifestations and objections when the agent determines how to act. The restatement or third of agency 202, 2006. But DART did not need implied authority. The statute granted DART express authority to take action to perform its duties to operate a regional transportation system, any power necessary or convenient. To effect the purpose of this chapter, Texas Transportation Code 452.054, in negotiating with GDS to provide the paratransit or the microtransit service, MV Transportation was exercising a necessary or convenient power that the statute expressly authorized DART to exercise in operating a regional public transit service, i.e., MV Transportation was performing a function of DART. Okay, I'm just explaining what the whole argument is going to be about this morning. In conclusion, GDS contests very little of MV Transportation's arguments, focusing almost exclusively on whether MV Transportation was performing a function of DART and negotiating for subcontracts with GDS to provide for services. It is apparent from the authorizing statute that those negotiations were a DART function, so GDS arguments don't defeat MV governmental immunity. So basically, from what I'm understanding over here, the argument is really going to come down to one thing. Did they have the authority to negotiate the contract that they negotiated? That's all. Okay, let's see if it's started yet. Let me go back one more. I'm so sorry, guys. I don't know why it's taking them so long to get started. No, they're still just sitting there. Okay, well, this is wild. we're on Texas time, so maybe it's going to start in a little bit. I don't know. There are actually 45 of us waiting for this to start. So we'll just leave it there and we'll talk about something else while we wait. I'm sorry, guys. Let's go see what the other brief is. So that was their brief. And then the brief on the merits. We'll keep reading these other briefs real quick. Now, here are the merits from the Supreme Court. This is what they're going to talk about over here. Oh, boy, this is a long one. This is the reply issue. The damage amount limits under section 452.05 D of Texas Transportation Codes are only applicable to a case in which private contractors of transportation authorities is sued for that private contractor's performance of the same function that it was performing for transportation authorities. GDS sued MV Transportation for fraudulent concealment and misrepresentations that were not part of the functions MV Transportation was performing for DART. So MV Transportation does not get the benefit of 452.056D or the damage limits. Statement regarding jurisdiction. Pursuant to a Texas Government Code 22.001, the Supreme Court has appellate jurisdiction, except in criminal law matters of an appellable order or a judgment of the trial courts if the court determines that the appeal presents a question of law that is important to jurisprudence of the state. Okay. So MV Transportation states the following as its basis for this court's jurisdiction. This court has jurisdiction under Texas Government Code 22.001 because, number one, the petition for review challenges a judgment of a Texas Court of Appeals and an appeal from the district court's final judgments. And number two, the petition addresses the statute limiting liabilities for contractors performing functions of a regional transportation agency. So it does not say anything about why this appeal presents questions of law that is important to the jurisprudence of the state, as required by Texas Government Code 22.001A. This case is not important to the jurisprudence of the states because it's very unusual in the facts and it's limited to the one narrow issue regarding one cause, GDS allegations of MV Transportation's fraudulent concealment of a material fact and fraudulent misrepresentations, which were outside of the function of MV Transportation's, which they were performing for DART. These are not issues likely to arise in future cases against contractors for transportation authorities. It seems to me like it's kind of like a waste of, it seems like it's kind of like a waste of the Supreme Court's time, to be honest with you. I mean, but who am I? I'm not an attorney. I'm just a mom, you know. So the Court of Appeals opinion correctly stated the facts, but a more thorough discussion of the facts that led to the fraud allegations could aid this court in determining whether petitioner's argument about applying the Texas Transportation Code to GDS's fraud claims, thereby limiting damages on such claims to be zero, is valid. See, they're trying to get out of paying for something. That's what it is. Indy something. Hello, good to see you. Good to see you. Let's see, what's this? Indefinite centers. Okay, thank you. Thank you for coming in. I know we're running late. It's because the Supreme Court has not started yet. I understand it's 9:38 and they still have not started, which is very odd because the hearings were from 9 to 12 this morning. So we were actually just reading the statement or the brief from the first hearing that's supposed to, the person that's going to go first over here. Okay, so just bear with us. We're so sorry. I don't like to waste people's time. And I feel bad that we're just sitting and waiting, but they haven't started yet. There's nothing I can do other than read the brief. And so we're just going to read the brief. So we'll be ready to talk about it once they've had the hearing, and we can make our own decisions as to whether we think they're right or they're wrong. So prior to submitting its proposal, GDS met with and exchanged emails with MV Transportation, MV Contract, and DART concerning several issues that would affect the amount of GDS's proposal for the subcontract. GDS has been told that the contract would not follow the typical public transit business model of vendors being paid on an hourly basis, and that MV Transportation's master agreement with DART had changed the payment model to be per trip basis. Okay, GDS was induced to accept the change in pricing by the following. The representations of how many trips were expected and how much would be paid for each trip. Now, this is a lot of money. Okay, we're talking about a lot of money here. Yeah. $165,000 for annual trips at $21 per trip. Okay, I'm sorry. 165,000 trips. Okay, the trips at $21 per trip. $3,465,903. $3,465,903 divided by 42 paratransit buses is $82,521 in revenue per bus per year. $82,521 divided by 2,080, which is an annual work hour based on 40 hours per week, equals $39.67. This is within 8 cents of the original hourly price. So the whole bitch is about 8 cents difference in price. That's what it boils down to. 8 cents difference in price. That is crazy, right? Okay. GDS relied on the fact that MV Transportation had provided DART with ADA compliant transit services for 9 years. So it should have reliable data to accurately predict the number of trips needed to determine the pricing structure that MV/GDS subcontracts. Okay. Move this down out of the way. There we go. MV Transportation also informed GDS that DART would be using the Route Match, the highly routed new software that MV Transportation had developed. Okay, so they're going to use their own their own software. So they changed the price and made them use the software that their company had developed. Okay. MV Transportation also included that GDS would be, okay, that's going to happen. And that MV Transportation said that its efficiencies would allow GDS businesses to be profitable with the per trip compensation model. Relying on those representations, GDS agreed to the pricing schedule in the MV GDS subcontract and purchased 57 buses at a cost of $3.4 million for 57 buses. Then hired and trained personnel to operate the number of buses necessary to meet the promised 165,000 plus trips per year. In the information in MV's transportation price exhibit regarding expected revenue based on the number of trips and the touted efficiency of the Route Match software had been true, that would have allowed GDS to continue as a successful company. Unfortunately, the number of trips actually directed to GDS was much less than the number in the pricing schedule. There were multiple cancellations that MV Contract Transportation failed to inform GDS of. So it paid drivers to show up, but received no revenues from the trips. GDS hoped that the numbers would get to the represented estimate. So for several months, it subsidized DART's paratransit operations, providing uncompensated services excess of 100. Okay. So they were not getting what they were promised. And so they just, I guess, basically paid them. They paid them for not doing the work to subsidize because they promised. What they promised was not delivered. This is what's happening here in this case. Immediately upon the start of the contract, there were major problems with the Route Match software. Terminated the software, which meant the master agreement of the MV GDS subcontract were no longer performable by any party thereto as originally contracted. And DART replaced the Route Match with Trapeze, which is an older and much less complex software that was not compliant with the GDS agreements or the software requirements. The Trapeze software was not a comprehensive system for dispatching, scheduling, reservations, or other functions that determined were crucial to GDS's operations. It only made matters worse for GDS. With the failure of the Route Match, DART and MV Transport were faced with a failed implementation and execution of the new model, which caused GDS significant damages. GDS asked DART to follow its usual policy of modifying the master agreement for the applicable price adjustments in the event of the contractor furnished data of any description, for example, the use of Route Match, that was not accurate. DART would not address GDS's final concerns because the master agreement required DART to relinquish to MV Transportation complete control of the system, including any contact with all providers. Transportation chose to do nothing to address the financial impact of the Route Match failures on GDS. Okay, so they were sold a software that did not work. A lot of companies end up with software that doesn't work for them, and they have to make a change. They have to go back and use a different software. This is not. I mean, it happens all the time in business. Look, bank. If you ever notice your local bank, they change software all the time. You've seen that. You end up like they went from using the Visa debit card to the MasterCard debit card. Well, that's a big change. You know, everybody and ask us customers, we don't get a choice. We just have to get whatever debit card that they're offering. It doesn't matter if we like Visa or MasterCard. It's up to the bank, and it's all done. It's all based on the profit margin because every transaction that you use a debit or credit card for, the merchant who accepted that card is charged 3%, right? So that that cost is passed on to you, the consumer. So, I mean, everybody has to make money in the deal, and that's what the whole complaint over here is: the amount of money versus what they were told versus what they actually ended up with. And it started because their software did not work. So here's the summary of the argument. GDS pled that MV Transportation made fraudulent misrepresentations and fraudulently failed to disclose essential information in order to persuade GDS to sign an agreement with MV Contract. In doing so, MVT was not performing a function of a transportation authority. Petitioner's motion to dismiss GD's claims was predominantly based upon an assertion that it had governmental immunity as a contractor with DART. Both sides' briefs in the Court of Appeals focused on the governmental immunity issue, as did the Court of Appeals opinion. It found that MV Transportation did not have governmental immunity either under statutes or under the common law. GDS Transport LLC versus MV Transport Inc., 2024, and then it gives the citing numbers. MV Transportation does not appeal to the Court of Appeals, finding that the trial court erred in dismissing GDS's breach of contract claim based on vehicle lease agreements, or it's finding that MV Transportation is not allowed DART derivative governmental immunity due to the total control it had under its contract with DART. Instead, MV Transportation is arguing that the language in the Transportation Code provisions that the Court of Appeals held did not give MV Transportation governmental immunity still defeats GDS's fraud allegations against MV Transportation's. It argues that since the amount of damages would be zero based on GDS's inability to sue DART directly for MV Transportation's fraudulent misrepresentation, because the suit for fraud against DART is not waived under the Texas Tort Claims Act. And then, even if GDS could sue MV Transportation for fraud, the damages would be zero, so the cause of action should be dismissed under Rule 91A. Okay? Petitioner's agreement fails because it's based upon Texas transportation codes, and conditions for the damages against the contractors are limited to the same function of itself. MV Transportation says the function it was performing for DART were managing and operating all of DART's microtransit and paratransit operations. However, GDS alleges that MV Transportation committed fraud by lying to GDS about several factors, and that GDS would need to base its upcoming bid to MV Contract, not MV Transportation. That process was not part of the functions that MV Transportation was performing for DART, so the damages are limited to Section 452.056D is not triggered. Arguments and authorities. This is a short little. Let me see if they're started. Let me see if they started yet. Hang on, guys. I know I really wanted to get started too. I want to hear it. Let's see. It says now we have 58 people still waiting. We're still waiting. We'll just keep reading while we wait. It's okay. We'll just keep reading. A party may move to dismiss a cause of action on the grounds that it has no basis in law or fact under Texas Code P91A. A cause of action has no basis in fact if no reasonable person could believe the facts pleaded. A cause of action has no basis in law if the allegations taken as true, together with the inferences reasonably drawn from them, do not entitle the claimant to the relief sought. In ruling on 91A, a motion, a court may not consider evidence and must decide the motion based solely on the pleadings of the cause of action. A Rule 91 motion in review, and then it gives a citing. I'm not going to read all the citings. Whether a defendant is entitled to dismissal under the facts alleged is a legal question. And see, I'm going to agree with that. And because Rule 91 provides a harsh remedy, the rule's requirements are strictly construed. Number B. Okay, this is B, argument and authorities. Texas Transportation Code. The Texas Transportation Code states in pertinent part to the following: an independent contractor of the authority that on or after June 14th, 1998, performs a function of the authority or an entity described by Section 452.0561 that is created to provide transportation services is liable for the damages only to the extent that the authority or entity would be liable if the authority or the entity itself were performing the function. Okay. The Texas Transportation Code, which 452.056D, Petitioner's argument that grants the functional equivalent of immunity from liability from any dollar amounts. See how they all just they make all these laws and rules to protect themselves, because you don't want to, if you're going to file a suit against the state or any entity of the state, they don't want you to be able to have a claim, so they're going to make sure that the liability would be zero, which is what they're trying to do here. So petitioner faults the Court of Appeals for construing its argument under 452.056 solely as an argument for derivative immunity. Remember who else had derivative immunity? Miss Soto. That's right. I remember that case. Petitioner makes a point. Petitioner makes a point of saying it never used the term derivative governmental immunity in its briefing in the Court of Appeals, and says the Court of Appeals erred in focusing totally on the immunity issue. The petitioner then says that the legislature granted an independent contractor performing the function as a transit authority the functional equivalent of immunity from liability for intentional torts, and it cites a bunch of cases. Petitioner's argument is creative. It's kind of funny what it says here. Petitioner's argument is a creative attempt to get around the governmental immunity issues on which it lost the appeal. It argues that since DART could not be sued for fraud because there is no waiver of immunity for such a cause of action in Texas tort claims, that DART's liability for damages for fraud would always be zero. It then argues that since the Code of Texas Transportation limits the liability of a contractor with a transportation authority to the damages could be recoverable against the authority, it means that GDS could recover zero in fraud for damages from MB Transportation. So GDS's cause of actions for the fraud should be dismissed. The argument does not give MB Transportation the relief sought because it is based upon conditions that the limitations of liability applies if the contractor was performing a function of the authority. But GDS is not suing MB Transportation over a function it was performing for DART. Under MB Transportation's multiple rules of statutory construction discussed in its brief, it can only be interpreted as meaning the function that the contractor was sued for performing is the same function of the authority to which the limit is zero. In stating what functions DART that MB Transportation was performing when it was accused of fraudulent conduct for GDS, MB Transportation says that DART delegated its responsibility to manage and operate all of DART's microtransit or paratransit functions. Making fraudulent misrepresentations to induce a subcontractor to give unrealistically low prices in a proposal is not part of managing or operating DART's microtransit or paratransit functions. MB Transportation is not, therefore, entitled to the damage limits provided by 452.056 because it was not performing any function DART had delegated to perform. MB Transportation claims that since soliciting such a third-party contract and negotiating with a party of the contract's terms constitutes a DART function. Boy, they are stretching a little bit on this one, I will say that. However, soliciting and negotiating a third-party contract is not managing or operating all of DART's microtransit functions that MB Transportation was performing for DART. In fact, MB Transportation did not even contact, in fact, MB Transportation did not even contract with GDS. In making the fraudulent misrepresentations, GDS, and fraudulently concealing important facts from GDS, MB Transportation was simply trying to increase revenue for its subsidiary companies, which did contract with GDS by decreasing the company's expenses. Wow, they might actually have an argument here, okay? They might actually have an argument, guys. Petitioner argues that as a result, MB Transportation has liability to the extent of DART's liability had DART been soliciting and negotiating with GDS. Again, saying DART's liability would have been zero. That is a wrong interpretation of the statute, which applies when the contractor is performing the function for the authority, not just when the contractor is performing any function the authority could perform under its own authority. Petitioner cites Martin K. EB Construction versus LAN STV, and then it cites that whole case. To support its argument, it quotes the finding that the determination of whether the independent contractor is entitled to to derivative governmental immunity from liability depends on the analysis of the function performed, not simply by the characterization of the claim. This is exactly what GDS is asking this court to do, to analyze the function performed by MV Transportation for which it was sued. MV Transportation represents the GDS to induce it to contract with MV Contract. That analysis shows that MV Transportation was not then performing the function it says DART delegated to it, managing or operating DART's microtransit paratransit functions. Thus, an analysis under Martin K. EB case favors GDS's position. Petitioner cites that GLF Construction Corp. Versus LAN, and it gets a big old citing, claims that it supports the interpretation of 452.056 that the petitioner asked this court to make. However, it supports the GDS's position. The court specifically notes, as the language of the statute plainly states, LAN-STB is liable only to the extent that the DART itself would be liable had it performed the same function. GLF Construction Corp., and then it's like 414F3D at 55. This is another statute, okay? In this case, DART performed a different function than the function for which GDS sues the MT Transportation. This is the conclusion. I wish they would get started. Conclusion and prayer for relief. The petitioner's arguments do not support the very narrow issue that it's asked the court to grant for review. Even if the arguments were correct, the issue is not sufficiently important to the jurisprudence of the state of Texas for this court to grant the petition. Respondents, GDS Transport LLC, prays that the court affirms the court's appeals, opinion, and judgment and remands this case to the trial court for further proceedings consistent with the opinion and judgment, and award the respondent costs incurred in this court, and respondent prays for such other relief to which it is justly entitled. Okay. Why haven't they started yet? Let me go see. Let me see what's going on here. Oh my God, everybody's waiting. We have 63 people waiting to watch this, and they're still not starting. Okay. Well, I don't know. I guess we'll just talk about something else while we wait. We'll just do that. But that is the brief, and that's what's going on. And all we can do is just wait for them to start so we can talk about it. Let's see. Is there anything else over here that I need to read? Let's see. Motion for extension of time. Well, no, we're not going to read those. Let's see what else is going on. We'll go look and see what else is going on in the world of YouTube today while we wait on the Supreme Court to start, because they've not started. Is there any other Supreme Court hearings today? Let's see. Supreme Court's anywhere. Let's just check it out. Okay. Hearings. Let's see. Well, I don't want to watch that. We don't want to watch that. Okay, Supreme Court cases for dummies. No, we don't want to watch that. What went down during the last hearing? Okay, the only two existing. Okay, I don't want to watch the Supreme Court of the United States because I don't want to watch arguments about Trump. That's really not important to me. It's important, but I don't really want to talk about politics on my channel. I want to talk about, things that are happening in my state, things that are happening in other states. Let's go pull up Colorado Supreme Court. Let's see. While we wait for Texas to start. Okay. 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 Let's see. Let's see what's going on. Well, you know what we're going to watch? Let's just go back and watch Letitia Stouch's Supreme Court hearing while we wait for Texas to start. Let's do that. We can watch that. We'll watch this. This was a month ago. Let's just watch.
Firing reversal.
Okay. So we're going to watch Jennifer Knight's. Well, I really don't. Oh, it's fine. We'll just watch this for a minute. Okay. So we're going to watch Letitia Stouch's case.
Same way that she was plotting her criminal defense before she was even arrested. You know, when she was faking polygraphs and talking about how the jury wouldn't even be able to hear the information about the polygraph. You know, she's already imagining.
Okay, we are simply watching the old Letitia Stouch Supreme Court hearing in Colorado while we wait on the Texas Supreme Court to start, because they have not started yet, and it is already 9. It's almost 10 o'clock in the morning, and so I don't want to have y'all holding and watching nothing. So we're going to rewatch this court hearing as we're waiting for this decision to come out. Here we go. Thank you.
She's already imagining a jury, and she hasn't even been arrested yet. And I can almost assure you that she's done the same thing with her appeal.
Yes, ma'am, she
She's
has.
been thinking about her appeal, in my
From
opinion,
day one.
since before she was arrested.
Yep.
Anyway, so before we get started, you know, like I said, I wanted to take us back to May of 2023. And May of 2023 is when
I am Landon, Gana's mom,
Oh, this was so
and that will
powerful.
never change.
So powerful.
Once I was 7 years old, my mama told me, go make yourself some friends or you'll be lonely.
In that car ride, I remember it like it was yesterday.
Oh, this broke my heart.
oh, that's hard to watch. So we just finished a live stream about an hour ago where we reviewed Nicole Fierro's.
The Court of Appeals judges will review a series of past Colorado cases that shape the current laws. We reached out to the district attorney's office over her trial for comment. They sent us a statement, and we have that on our website. Reporting live here in Denver, Nicole Fierro, Fox 31.
And on the screen is an image.
Here we go.
You know,
We're just waiting
she said,
for time until
you know,
Texas starts.
I wondered if she would claim, you know, what's the one about ineffectiveness of counsel? You know, we don't see that here. These are the three that finally went to appeal 3 years after her conviction. So number one, the trial court's erroneous denial of a statutorily required challenge for cause of a juror who ultimately served on the jury is structural error requiring reversal. That's a mouthful.
And let me tell you this, and let me just discuss this for just a minute. In case you're not familiar with the case of Letitia Stout, she killed Gannon Stout, she hid his body, tried to act like she was crazy. I mean, the Letitia Stout case is really one to study, actually. This particular document was sealed by the court, by the Colorado Supreme Court. It was not to be issued. I don't know how this person got this document, but it was sealed. I know that these are the facts, but I'm just letting you know that how she got these, I don't understand, because I've asked for them multiple times in every different way that I can. And now that this case has actually been to the Supreme Court and we're waiting on the decision, the case documents are still sealed in the Supreme Court of Colorado, which is disgusting. I mean, once it's out there, you should release it. It should not be sealed. When I asked the court about why was this case sealed, they were explaining it's because the victim was a minor. If you remember, Gannon Stout is the person that Letitia Stout took the life of out of basically jealousy, as far as I'm concerned. In my opinion, it was all out of jealousy because she knew that Al would never love her the way that he loved his child. And that's the way it should be. A man should always love his children more than he loves his wife. I mean, that is your flesh and blood. You know, anyway, we'll just keep watching. Here we go while we wait on the Texas to start. Here we go. Let's see if we can get right to where they actually are hearing it. Here.
I'm going to just take a break. I want to get food. Look at my lips. They're chapped. I haven't. You want some food?
She's all concerned about herself as usual.
What do you want to eat? Okay, she just said I could be escorted out. Okay.
She's actually trying to leave.
You have my number. I haven't not.
You're done with all this?
Right. I haven't not communicated with you. I have been.
Are you done with that coke?
Nothing but.
She's not going to give them that can because she knows you're going to run to the
Yeah, I just didn't know if you were done with it. We recycle them too. So.
Oh, okay. Yeah.
Mm-hmm.
Okay. Hang tight for me just real quick. Let me make sure that she doesn't have any other questions because she finished up.
She just said.
Okay, I get that. I get that. Let's just let me double check with her.
She said I could go. That she.
Right.
But she finished up the interview. I don't know.
Holding me here?
I'm not holding you.
Yes, we are.
Walk me out.
You want to leave?
I will clearly answer your questions. I just want to take a break. Like I've literally followed all your.
Where do you want to go for your break?
Right. Where do you
want
to go?
I want to see my child. I want to get lunch with her.
Well, I'm more than happy to get you lunch or to bring your daughter here or whatever needs to happen.
Mm-hmm.
I'm not saying that you can't leave.
Yes, she is telling you
but
can't
I would
leave.
like to finish up this conversation with you. There's a couple of questions about Sunday that I had, and this is the first time that I'm hearing that you're sexually assaulted. So that would be, well, you came towards the door, so open the door. If you'd like to have a conversation in the room, we can.
She just wants to leave. That's what she
It's
wants
up
to
to
do.
you. But like I said, I missed out on a bunch. So am I be able to just go and chill out? Really? Just
Listen, hang on a second, guys. Let me see if they've started yet. This is really irritating. Oh boy. Okay. Court live. Here we go. No, they still have not started. 3-5, 3-3. Look, still nothing. Nothing. Okay. Well, all right, let's do this. We'll just keep let's see if we can hear. Let's hang on a second. Hang on a minute. Let me see if we can find something that's already been heard. This is from 3/18 of 2025. Supreme Court of Texas restrictives. That's 4 years. I don't want to watch something 4 years old. I want to watch something new, something from now. This is from 3/19. This is for today. Okay, y'all. It's still not up and going. It's so irritating. That's 4 years ago. Nobody wants to watch anything from 4 years ago. Well, we'll watch this for a second.
Government of the United States
So this
before
is going
this
to
court.
be
You have our sincere
the
appreciation.
Texas Supreme Court, and they're just discussion.
Thank you, Mr. Chief Justice.
Oral
Mr. Chief
argument,
Justice, and may it
2
please
years
the
old,
court, I have
but
the
it's
honor
not
to
today's
present to the
court.
court
Not
the
today.
Solicitor General of the United States, the
This is
Honorable
from March
Elizabeth
1st,
Barkas,
November
Prelogger
1st
of
of
FBI.
2021. Damn it, why are they not going yet?
Solicitor General Prelogger, the court welcomes you as the Solicitor General of the United States to the performance of the important office that you have assumed, representing the government of the United States before this court. I am pleased to note that you are the 48th Solicitor General of the United States. I also note that you are the 10th Solicitor General of Justice Thomas's tenure. You follow in the footsteps of other outstanding attorneys who have held your office. Your commission will be duly recorded by the clerk.
Thank you, Mr. Chief Justice. It will be an honor to serve.
Let's do this.
We'll hear.
We're going to go back to the Texas Supreme Court from 2 weeks ago, and we'll just watch something like that until we get it, until they start this morning. I don't know why this is late like this. It is strange. Supreme Court is supposed to start on time. You know, I don't get it. February. Let's see what they had in February that we could watch. Okay. Okay. Oral arguments. Let's see. This is crazy. Why? I don't understand. It's ruining my whole live stream, you know? Just ruining my whole live stream, Mr. Texas Oral Supreme Court. Where are you? Here, we'll listen to this one from the 25th.
There's 4 issues that were brought up, and we're here to the issues that were designated were issue number 2 and issue number 4.
This is from the 25th.
In this case, the concurrent cause instruction that appellant claims should have been given, there was no facts to support issuing such an instruction. The concurrent cause definition is under 6.04. And in there's 2 requirements that are needed in order to be given the instruction. There has to be evidence that there was an agency, in addition to the actor, that was a but-for cause of the result charged.
You don't think that a surgery being performed on the guy could potentially be an agency that contributed even to the death?
That is.
I mean, that's some evidence.
This is from February the 25th.
The examples given of a concurrent cause are usually things that are happening simultaneously, I would say. In the Sear v. State case by this court, it gives the example of 2 arsonists burning buildings at the same time, one on one end, one at the other end. It's happening concurrently at the same time. That's more of an issue of concurrent cause.
Well, this guy did not die on the day he was shot.
That's correct.
He stayed alive, until they had a surgery on the guy, and then and then he expired. So, I mean, don't you see the argument there, at least factually?
I mean, I I see the argument. I do believe though that he was not entitled to the instruction because the CRV State case does lay out that both prongs are necessary. And one of the prongs includes that the appellant's conduct itself has to be clearly insufficient to cause the harm. I think he certainly loses on that prong.
That's the prong I want you to focus on.
Okay. Yes.
Trooper Sanchez was shot in the head.
Correct. Close
causing
range.
massive brain damage, which ultimately increased the pressure in the head, causing hypoxic ischemia, which was the principal cause of death.
That's
How is there evidence that, if we use that second part, the defendant's conduct was clearly insufficient to produce the result?
That's exactly correct. The conduct of shooting somebody in the head close range with a .357 Magnum is always going to be an act that's capable of causing the result in this case, which was the death of Trooper Moises Sanchez.
Can you shed some light on the dispute as to whether or not he was in a coma the entire time?
He was that, and the
defense says no, correct?
That's correct. I don't think there was any evidence that he was actually getting any better. The defense did
Not any better, but did he actually come out of the coma and
There we
talk to
go.
anybody during that time?
No,
Again, this
there
is
was
from
no
2 weeks
evidence of
ago
that.
as we
That was
wait on them
presented
to
in the
start this
record.
morning.
The appellant did point out to the fact that there was healing on the outside of his head. However, the expert, Dr. Sandberg, testified that the deterioration commenced when the bullet hit the brain. That's when he started deteriorating, and that's what led to the hypoxia ischemia, which ultimately led to his death. But all of this, of course, was commenced from the appellant's actions himself, which was the cause of his death.
Well, let me ask you this. So I get annoyed. I get pulled over for speeding, and I'm annoyed at the police officer, and I poke him in the eye with a dirty fingernail. And then he goes to the hospital, and they completely mess everything up, and he dies from sepsis.
Mhm.
How am I not on the hook from capital murder at that point?
Well, it depends on whether or not
That's
it was
a
an
good
act
question.
capable of causing.
I mean, I poked him in the eye, so it's an act capable of causing serious bodily injury, right?
That's correct.
So am I on the hook for capital murder? Even though my goal was,
arguably,
hey, aren't you blind? You didn't see me speeding. Boop. And then he dies of sepsis. Like, how am I not on the hook for capital murder at that point?
Arguably, you would be, yes.
Okay.
Arguably, you would be.
At least you're consistent. All right.
Yes.
Wow.
How does the access, just theoretical access to medical care, factor into the first part of this analysis?
Mhm.
Act clearly capable of causing death, right? So we've got someone who commits an offense that doesn't immediately kill somebody. There is always the prospect of getting them to a physician. And then there's the potential for that person to be saved by competent or perhaps exceptional or extraordinary, and those things are deprived to the victim.
Mhm.
If it's possible to have saved the person.
Okay, for fair use, we have to stop every once in a while and talk about it. This particular justice I really like. When he was overhearing the case that we discussed the other day, he was pretty upset at the behavior of the defense attorneys. I mean, of the prosecuting attorneys. He was fed up with them. He was done. He's ready to move on. You know what I have not done? I need to do this really fast. We need to go ahead and read our fair use disclosure. We have not done that this morning. Can't believe I forgot. I try to make sure that we read it every time we go live, just to protect ourselves, because we need to protect ourselves. In today's world on YouTube, there's so many copyright, there's so many this, there's so many that. It makes it so hard to actually keep your channel going. So let me go back and pull this up, my disclosure. Here we go. Go ahead and read that right now, and then we'll get back to watching. Maybe by then they'll get started. I was just so shocked that they're not live yet. So here we go. All right. Come on now, pull it up, pull it up, pull it up. Look how slow this is going this morning. That's wild. Okay. Okay. This is the standard fair use disclaimer for YouTube, etc. Copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for the purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing. This video is for commentary, educational, and news reporting purposes. All footage, images, and media use remain the property of their respective owners. That is our And in true crime, we also need to add, you read this? Yeah, I do need to read this because it's important, because I want to make sure that our copyright, that we don't infringe and that we don't be accused of being infringed upon. So there's a one specifically for true crime as well. This content is created for news reporting, commentary, and educational purposes under fair use, Section 107 of the Copyright Act of 1976. Any photos, court footage, or media shown are used for public interest discussion and remain the property of their respective owners. And there's our fair use. There's our fair use disclosure. Now, we'll get back to watching the Supreme Court. This is from 2 weeks ago. As we wait, I'm still watching, and they still have not started this morning, and it's already 10 o'clock. It is 10. Let me see what time it is. 10:15, I believe. It's 10:15, and they still aren't live, which is so shocking for a Texas Supreme Court. Here we go. Sorry, guys. I did not know that they were not going to be an hour late.
Also carry back into the question of whether.
Oh, yeah. Thank you, Cinderella. Yeah. I almost forgot. They were already an hour in.
That's correct. I would say yes. It does tie back to the defendant's conduct that commenced this need for medical care to begin with. And in fact, there is a case out of El Paso. I did cite it in my brief, Valdez v. State. It's a 2012 case wherein that court held that the appellant was not entitled to a concurrent cause instruction, where there was arguably questionable medical treatment. They said that the placement of a left chest tube might have caused injury. However, they said he was still not entitled to the instruction because his act of stabbing the victim was an act clearly sufficient to cause the death.
So in theory, the trial judge deciding whether to give this instruction or not should be asking, assume there is no such thing as medical care anymore, right? When the actor did the act, if it was clearly capable of causing death,
I think it would
that be enough?
I think the court would have to make the analysis on both prongs in order to make the determination, for sure.
So again, I want to draw your attention back to this question that I'm struggling with a little bit about whether or not this instruction is one that is always applicable to the facts, right? It's all, in other words, is it a defensive instruction? Is it only warranted when one of the parties asks for it? Or anytime that there is evidence that there may have been some other intervening factor, does it become law of the case so that the trial judge errs by not giving the instruction?
It depends on the facts that are presented in
So the facts can raise it, and that the facts themselves would require the judge to give the instruction.
Correct.
So there's no need for one of the parties to say, I would like to have a causation instruction here, Judge. The judge is just kind of required to give it.
Correct.
Okay.
Wait, would that be true? The hypothetical I gave earlier, I put a case of dynamite underneath somebody and blow them up, right? That act is clearly capable of causing death. Why would in a case like that, the judge be compelled, if no reasonable juror could come to any conclusion other than that the defendant's act was sufficient in and of itself to cause death? Why would he have to go further?
Well, I don't think he would have to give the instruction in that.
Okay, so that's the first, that would be the first question.
Right.
Do the facts in this case lend themselves to such the possible?
Let me tell you what they're talking about. Okay, for causation instructions in a court of law, which in criminal cases, this is what they're talking about. Causation instructions are the directions of a judge gives the jury explaining how they must decide whether the defendant legally caused the victim's death or the injury. Okay, in criminal cases like capital murder, the jury must find that beyond a reasonable doubt that the defendant's conduct caused the result. But for causation or actual cause, the jury is usually told to consider, would the result, death or injury, have occurred but for the defendant's conduct? If the answer is no, then actual causation is established. Example, if the victim would not have died, but the defendant's actions causations is met. Concurrent causation, sometimes more than one factor contributes to a death. Many states, including Texas, use language similar to this. A person is criminally responsible if the result would not have occurred but for his conduct, either alone or in concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the defendant's conduct clearly insufficient. This prevents a defendant from escaping liability just because another contributing factor existed. So that is why they're talking about causation in this particular case. Here we go.
Conclusion by a reasonable
Sometimes when I
juror
see this, it
that
looks
the
like
defendant's act
it looks like he's
did not
looking
cause
right at
death.
me.
I do not believe so. I think a firearm is a per se deadly weapon, so I don't even think it has to be an expert to conclude that this was an act capable of causing death. However, that's exactly what the experts did testify to, that it was death from complications from the gunshot wound.
Well, but had he not been shot, he would still be alive.
So yes, and then I think really what's going on here is that appellant is conflating the element of causation, just regular causation, with concurrent causation in trying to say that he was entitled to that instruction. But there's a difference between just but for regular causation, the element of the offense, and concurrent causation. I don't think this is a situation where the concurrent causation was warranted.
Do you think there's a time element here? Like, let's say, the trooper lived for 3 years and then this happened. Like, at what point is enough time passed where now we can start talking about concurrent causation?
I think it's possible. I think if the trooper would have made a complete recovery and been better than he was, got a complete recovery and then died from something else.
So the trooper gets well, but is let's say experiences dizzy spells, and then one day is walking the dog and falls over, hits his head, and dies. Is that?
That's a good question.
Do we have a capital murder? And if we have a capital murder, do we have a concurrent causation issue?
Yeah, it would depend on whether or not the expert.
See, that's a good question. I'm glad they brought that up, because this is something I've wondered about before myself. So, I mean, basically, if you're hit by a car and somebody was drunk driving, let's say somebody's drunk driving, they hit you and you're walking down the sidewalks and they're drunk driving. Well, you go to the hospital, you get well, you get better, right? And then all of a sudden, we'll say it's 2 years down the road, you get a little bump on your head, but you already had the previous head injury from the car accident. What liability does the old injury have to the new injury as far as what caused you to pass away now? Is it because it reopened the old injury? Is it because you were already weakened? What is the liability there? That's a really good question, because I think that in my mind, if in the case where you have been hit by a car, but you've had a full recovery or almost a full recovery, you're never going to be 100%, right? We always know that the human body can never become 100% again. It just doesn't happen that way once you've had a substantial injury. So the thing is, I think in my mind, if you've healed and you've went on with your life, and then 2 years down the road, let's say that you trip over the dog, and one of your old injuries flares up. No, it's not it has nothing to do with the old injury. I think it really has to do with whatever happened to you next, because you managed to move on. There should be a statute of limitations on when does the causation stop. There should be a statute of limitations. We'll just keep listening. I'm sorry, I just had to say that. I'm sorry. Let's keep going, guys.
The testimony can link it to
where are they?
The appellant being the cause of the.
But I mean, let's just say, there's no doubt, he was dizzy because he got shot in the head, and because he was dizzy, he fell and hit his head on the sidewalk and died.
Arguably, yeah, I think that maybe the instruction would be given then. But but that was not the situation in this case. I think also onto Judge Newell's point regarding the harm, there was no objection so it is an egregious harm analysis in this case. I think there was overwhelming evidence on the causation issue. I think that also he was not precluded from making the argument of attacking that there was reasonable doubt on the causation issue. In fact, the arguments were pretty extensive on that point. So it was definitely harmless error because of that. I don't think they can meet the egregious harm point on this issue, and they were not entitled to the instruction to begin with. On to issue number 4, that was also designated for oral arguments. The appellant complains of all the non-privileged jail communications that were monitored by the trial counsel.
Were any of them used?
Only one of them was entered in evidence, and it was a letter from the appellant.
Somebody upset because their jail calls were monitored and their mail was read before they got to see it, and something from this jail call or this mail was used in the trial court against them. So they're upset that this was allowed to be made available in the trial. Boy. But here's the thing. Once you are a property of the state of Texas, or you're in this county jail, or you're property of the county, whatever, You are told up front, all jail calls are recorded. You're told that they go through your mail. So if you don't want something to be used against you, don't put it on there and don't talk about it on the phone. They tell you don't do it. Here, let's keep listening. It's interesting though, isn't it?
Himself, wherein he signed his name as
hell are these
Trooper.
people?
None of the phone calls were used.
But the phone calls were not admitted. No, the trial judge did not permit the admission of the phone calls where he refers to himself as Trooper.
What was the point of admitting that piece of evidence that was admitted?
The fact that he had a lack of remorse, I would say, it was during the punishment phase, not during the guilt innocence phase.
But just to be clear, none of this material was offered at any time during the guilt innocence phase.
Correct. That's correct. That is correct. So this was admitted at the guilt innocence phase. Additionally, there was evidence apart from the non-privileged jail communications wherein he referred to himself as Trooper. In his, there was his disciplinary records that were admitted wherein he signed his name on a bench in his jail cell as Trooper, and that was not part of it. So even if you considered it erroneous for us to admit it, it would have nonetheless been harmless because it was admitted somewhere else. But yes, to prevail under the Equal Protection Clause, they have to show that the party was treated differently than other similarly situated
Oh, hey,
parties,
you know what?
and that the differential treatment did not have
The case that they are discussing right here is actually Victor Alejandro Godinez, the state of Texas. And this was a capital murder case, and this is about Victor Godinez and his mail, etc. Maybe we should have watched this whole trial. Maybe that's what we should do, is go back and watch a trial and then come back and watch the appellate part. But yeah, the live court has not started yet. It's still not started. There's 60 people waiting for it to start, but it hasn't started yet. So we'll just keep watching this here. But I just want to let you know what it's actually about.
rational government basis. I think they fell on both
Texas
of these
State
prongs.
Trooper
This was
is
a case.
capital murder.
Was the amount of the bond ever attacked?
I believe they did lower the bond, but he was not to a point where he could get out. He stayed in custody the
But was there
entire
any
time.
argument made the bond was excessive?
I'm sure there was, but I'm not exactly sure. But that's probably how it did happen. But I don't recall off the top of my head.
I'm not sure how things work in Hidalgo County, but when, let's say, some rich person with all kinds of money goes out and shoots a police officer in the head, leaving him to be, hospitalized in a coma for months and months, is that person likely to get out on bail while they're waiting trial?
No, not at all. Not at all. That's a very serious offense, and that's why the other factors when setting bail include the severity of the offense, the nature of the offense, the safety of the community, all of which have nothing to do with whether or not he's indigent or whether or not he has money. In fact, if he does have money, because of the severity, the judges can be inclined to even give a higher bond. That's a very
isn't capital murder where you're seeking the death
There
penalty?
should be no bond on capital murder.
Have to give bail.
That's correct. Under the Texas Constitution, it is possible for the district court not to give a bail amount at all for capital offenses. And in this case, he was charged with 3 capital offenses. Woo. The one that we're here for, the capital murder that we're here and before this court, and then 2 attempted capital murders that are pending in the 13th Court of Appeals. Yes. But yes, I also, even assuming that there was a violation of his equal protection rights, he would still have to show that
every one of these guys use the appellate courts to claim that their rights were violated, every single one of them. But let's go back right now while we wait. I don't know if they're going to show the Texas Supreme Court oral arguments from today after the hearings are over, or if they're going to. I don't know what they're going to do. They're still not live. But let's go listen to Mr. Godinez, his confession as it was told in court. Let's go listen to that really quick. I think that'll be interesting. Okay, hang on, guys. Let's pull that up. Jurors here, his okay, and this is a state of Texas trooper. Who decided to just take the lives of people, I guess. His name is Godinez, is his last name. Okay. Oops. Hang on a minute, guys. And let's hear his confession. That'd be fun while we wait. Okay, we're going to listen to his confession, and
Today,
this
for
is
the
going to
first
be
time, jurors heard from a
ARGV.
suspected cop killer.
ARGV.
Investigators
Here we go.
interviewed Victor
we
Godinez
go.
after he was
Here we go.
arrested in
Let's
the
listen to-
shooting of Trooper Moises Sanchez.
And today, prosecutors played that interview in the courtroom. Here's Christian Von Preissing with today's trial developments.
Today in the 389th District Court, week 2 of a Valley Capital murder case. Victor Godinez on trial, accused of killing DPS Trooper Moises Sanchez. For 6 days, he's maintained the silence. Jurors heard from him today in a confession recorded nearly 5 years ago. Today, the 3-hour interview taped the day after the shooting said much more. When investigators asked what happened, Godinez said, quote, "I ran the red light. I'm not sure. I don't remember. Then I crashed. I was scared. I was drunk. I crossed the street, and then I took off running. The next thing I remember, I was shooting the officer." Judge Letty Lopez does not permit audio recordings in this case, so we have to quote what was said. Godinez was interviewed by Texas Rangers BJ Hill and Tony Rocha
Well, you
in
know what, though?
2019. In the recording, we could hear
At
Rocha
the,
first take a gentle tone and ask, quote, "Why did you get scared, bro?" Godinez repeated that he was drunk, couldn't
Hang on,
remember
I know
certain things, and
you
was
have it.
scared after causing that crash at 10th and Freddie Gonzalez. He told investigators he went back to his truck to grab a .357 Magnum revolver and extra ammo. He told them he liked guns and that he applied to be a police officer 2 years earlier and was denied. Quote, "Do you think he'll make it?" Godinez asked at one point. Trooper Moises Sanchez lived 4 more months after being shot in the head that night. Quote, "You would have bonded out already."
See, that is why they're doing the causation, because he lived 4 months after being shot in the head and then he passed away. So that is why there's a causation in the appeal. Now I get it. Here we go.
For a misdemeanor
Yeah, so he had a misdemeanor DD. I want to hear the actual confession. I don't want to hear them talking about it. I know it's out there somewhere. Not the jurors. Let's just hear it. Let's listen to this confession over here. Okay, confession. Here, let's see. I know it's taped somewhere. It's not just going to be only in the court system. Let's see. I'll go back and look for just a second. Well, maybe it's not. Man, you'd think that it would be. Okay. Let's see. Here we go. Let's pull this up this way while we wait. All right, we're gonna have to listen to it this way. There's no other way to listen
For
to
the
it.
first
I guess
time,
we don't get to
jurors
hear it
heard
from the
a
actual
suspected cop killer.
cops.
Investigators interviewed Victor Godinez.
Victor Godinez on trial, accused of killing
go look and
DPS
see.
Trooper Moises Sanchez. For 6 days, he's maintained the silence. Jurors heard from him today in a confession
Damn it, come on,
recorded
court.
nearly 5 years ago. Today, the 3-hour interview taped the day after the shooting said much more. When investigators asked what happened, Godinez said, quote, "I ran the red light. I'm not sure. I don't remember. Then I crashed. I was
Oh, my
scared.
dogs are gonna
I
bark
was
a little
drunk.
bit.
I crossed the street, and then I took off running. The next thing I remember, I was shooting the
Oh,
officer."
man.
Judge Letty Lopez does not permit audio recordings in this case, so we have to quote what was said. Godinez was interviewed by Texas Rangers BJ Hill and Tony Rocha in 2019. In the recording, we could hear Rocha first take a gentle tone and ask, quote, "Why did you get scared, bro?" Godinez repeated that he was drunk, couldn't remember certain things, and was scared after causing that crash at 10th and Freddie Gonzalez. He told investigators he went back to his truck to grab a .357 Magnum revolver and extra ammo. He told them he liked guns and that he applied to be a police officer 2 years earlier and was denied. Quote, "Do you think he'll make it?" Godinez asked at one point. Trooper Moises Sanchez lived 4 more months after being shot in the head that night. Quote, "You would have bonded out already for a misdemeanor DWI," said Ranger Hill. He suggested there could have been a different outcome if Godinez made different choices that night, instead of all the actions he's now accused of making after running a red light. After his arrest, Godinez remained in jail until this trial, nearly 5 years later,
5 years.
charged with capital murder. Christian Von Preissing, Channel 5 News.
In a Dallas courtroom today, our Robbie Owens heard.
So the guy he runs a red light. He's DWI. He kills the police officer and he has to sit in jail for 5 years, awaiting trial for his capital murder trial because he killed a police officer. Let me ask you something. Do you think 5 years is too long to be sitting in jail to wait for a hearing, to wait for a trial to start? Because in my book, it is. And I'm not saying they need to rush into it. I'm just saying it should never take 5 years to take a defendant to trial, no matter what the charge is. 5 years is too long. It just is. Okay, so here's where we're at right now. We go back to the Texas Supreme Court. They have not started yet. I don't know what the problem is. It's really
Today, for the
bothering
first
me,
time,
but we'll see what we
jurors
can
heard
do.
from a suspected cop killer. Investigators interviewed Victor Godinez
Texas
after he
Supreme
was
Court.
arrested in the shooting of Trooper Moises Sanchez.
And today, prosecutors played that interview in the courtroom. Here's Chris.
Okay, let's get today's. As you can see, they still have not started. It is still not started. I don't know why. I might have to sign off and come back on later because I don't want to leave y'all hanging all this time while we wait for them to get started. To me, this is very odd that it's already almost 11 o'clock and they still have not. It's 10:34 and they still are not showing us the live court hearing. Okay, so let's just come back later after I know it started. I'll keep watching, and once it gets started, I'll just jump back on and we'll go ahead and listen to today's hearings. But the only other thing we could do, hang on just a second, is maybe go out and listen to Corey Richards today. I have not been covering this trial. I've not been keeping up with Corey Richards, so I'm not sure what's going on. But we can watch a little bit of it while we wait. Let's see. Let's see what's going on today over here with Corey Richards. Let's see who's showing it. Utah, this is Long Crime, and this is Court TV. Who else is showing it today? Here we go. Let's go with Long Crime. There we go. Wonder what's going on here. Are they taking a break or what? Okay, here we go.
People use things, but those
All
are
right.
probably the most.
So this is the Corey Richards trial, and she poisoned her husband, if you remember, in Utah. This is day 6 of this trial. I'm just jumping on to give just a few more minutes to see if Texas does their job.
Fentanyl is
And
also
I'm sorry,
available in
but
patches and
let me
lozenges
see.
and other
We're watching
forms.
Court. I believe we're watching Court TV.
It can get into the system in a lot of different.
Sorry, guys. I'm so sorry.
In terms of what your body does with it, fentanyl in specific is metabolized primarily by your liver. There's what they call a CYP enzyme that is primarily responsible for the metabolism of fentanyl in your liver. That metabolism is felt to be mostly.
Yeah, I'm going to give them just a few more
determined by
minutes,
how
and then
much
I'm going to
blood
have to
is
call
flowing
her.
through the liver. So the more
I'm
blood
sorry,
flow you
guys. I
have
don't
to
know
the
why they're
liver,
not live.
the more rapidly it will be
Texas Supreme
metabolized.
Court, we're running my live today.
There are other ways that sometimes people
Makes me just want to take the whole
metabolize it
thing
more
down because they're
slowly,
ruining it.
but based on what specific genes they have for metabolism or for that metabolizing enzyme, but mostly it's a function of how much blood is flowing through the liver. And it's then converted very quickly, has a very short half-life in the body, minutes,
It's a damn
and it's
shame.
converted to a substance called norfentanyl, which then is eliminated in the urine. Don't know if that covered all
yeah, that's great. Thank you. Once it gets into the blood, then what's the intoxicating effect? I mean, how does that function?
Sure. So fentanyl in the blood distributes throughout the body. It's absorbed
Fentanyl is
either
so
through
dangerous.
the mucosa, the lining of the mouth, or directly into veins, whatever. It gets into the bloodstream. And then from there, it gets into the brain, it gets into other organs. Where it exerts its primary effects on the brain and the central nervous system, where it causes respiratory depression and or cessation. Can also cause central nervous system depression, meaning it alters the way you think, can make you groggy or less than normally responsive and things. But its primary lethal effects are related to its effects on your breathing. And it is dose dependent, so a higher dose will do this more readily than a lower dose, but it will either slow or stop your breathing, and sometimes that has lethal consequences.
The lethal consequences then are from stopping breathing?
Yes.
Okay. And when you stop breathing, death ensues. Does that metabolizing process continue to happen, or does that stop as well?
Generally, it will stop. There are, once your circulation stops and blood is no longer flowing through the liver, you're not going to have that continued metabolism through the liver. But there are a number of changes, large number of changes that are described in the way fentanyl is present in the body after death. That are related to changes in the pH of the body as you start to decompose, and other things that will influence what those levels look like.
When a person I'm going to give you a hypothetical. So we have a decedent, and in the blood, you and the lab personnel determine that there is quetiapine below the threshold of their tools. There is fentanyl at 15 nanograms per milliliter. And then in the gastric fluid, there is quetiapine at about 16,000 nanograms per milliliter and fentanyl at 20,000 nanograms per milliliter. My question then is, based on that hypothetical, is there sufficient information for you to determine whether those two drugs were taken simultaneously or sequentially, and if sequentially, which one came first?
I can't tell you that.
There's just not enough information?
No, you can't derive that information from those values.
Okay.
Okay.
I just wanted to follow up. You said there's drowsiness as a consequence of taking, I assume, opioids of any type. Fentanyl just happens to be stronger?
Yes, fentanyl on a weight by weight.
The thing about it is not everybody that takes, when you take opioids, not everybody gets drowsy. There are people who it has the opposite effect on, and which is basically means that you have an allergy to the drug, but not everybody gets drowsy.
Basis, 1 milligram of fentanyl compared to 1 milligram of oxycodone or of morphine is sort of the usual reference standard because it is the classic opiate medication. Fentanyl is just much, much more potent, 80 to 100 times more potent.
Ooh.
So you
100
said
times.
there's depression of the respiratory system, drowsiness. How quickly might one start to metabolize, given the fact that they take some fentanyl and it causes their death? Would they be able to metabolize at least some of it?
You would expect so, yes.
Okay.
I mean, there are a number of overdose deaths reported in the literature where the death occurs so quickly, and these are primarily in the setting of intravenous drug use, that no metabolism is able to be recorded because they just die too quickly.
Damn, that's bad.
But, generally speaking, we see some level of metabolism.
Let me see. I wanted to. But someone takes an overdose, a fatal dose of fentanyl.
Well,
it's not then instantaneous.
it almost is.
It depends partly. I mean, generally speaking, no. It's a function of the dose and the route of administration. So it's going to get into the system more quickly as an IV or smoking will generally get it there pretty quickly as well. But ingestion would delay that somewhat. But however it gets into the body is going to determine how quickly that happens.
In this case, we have the two things, I think. One is there's some fentanyl in the stomach, the 20,000 nanograms.
Yes.
And also a measurement of, I know I'm saying it incorrectly, acetyl fentanyl.
Acetyl fentanyl, yes.
Does that is that information help you determine how it was ingested in this case?
It's suggestive that it's an oral ingestion. The presence of a large amount of fentanyl in the stomach, sort of the rough equivalent of, several milligrams by volume is,
unbelievable.
Suggests that it was taken by that route, but there's not any way to definitely know that. There is some literature that suggests that the stomach will concentrate it, regardless of where it's from, but it is suggestive of that. And the presence of acetyl fentanyl in the stomach is also consistent with, is more consistent with this being illicit fentanyl than otherwise. Acetyl fentanyl is a variant of fentanyl that is, in our office, certainly we've only seen it in the setting of illicitly manufactured fentanyl.
When a body comes in for autopsy, in this case, Mr. Richens' body comes in, is it routine to check for injection sites?
Yes.
And
in this case in particular, there was visible pulmonary edema described at the scene, foam coming out of the mouth, and that is most commonly in somebody who didn't drown or have a history of heart failure is concerning for an opiate overdose, and so we would, in that case, do a thorough check for those.
Oh, for
injection
sites, and none.
I wonder if I can get into that account over there.
Again, I did not do the exam. None are described, and none were discussed by Dr. Ulmer.
Okay.
And I didn't see any in the photographs.
When you, in cases where you've seen an overdose death, particularly an accidental overdose death where you suspected inhalation, what's the sort of evidence that you would expect to see?
I'm not sure what you mean, inhalation of the substance?
Of fentanyl or opiates.
Yeah, they all kind of look the same from that regard. You may see evidence that they've been smoking. Sometimes you'll see little burns on their fingers or other things from heating it up to smoke it, because they're not actually smoking it in the same way that you smoke a cigarette where you light it on fire and then you're inhaling the smoke. What actually is happening is that drug is being heated up and vaporized, and you're inhaling the vapors.
So in those cases, do you tend to see evidence of that heating up? That is tinfoil or torches?
Certainly, yes, those things can be present at the scene.
Okay.
Commonly are seen at the scene.
Okay. Now, is it common for the people who are left behind to call the ME's office to find out what's happening in the case of their deceased person?
I wouldn't say it's common, but it's not uncommon. I mean, I spend a lot of time, most days I was in the office speaking with family members.
Typically that would be whoever did the autopsy would be talking to the person who's calling?
Yes.
Okay. Dr. Ulmer retired in January of 2023?
Yeah, technically her last day of work was the end of December of 22.
Okay. And did you receive a call from Corey Richens then?
I did, subsequent to her retirement.
And did you return her call?
I believe I didn't return her call. I believe she was just put on hold and then connected with me.
Okay. Have you had an opportunity to listen to a recording of that phone call?
Yes, I'm not sure where it came from either, but yeah.
Is it consistent with your recollection of that phone call?
I did not have any independent recollection of it until I heard it, but yes, it's me on the phone call.
Okay. And have you had a chance to look at the transcript of it?
I have.
Okay. And is that accurate to your,
yes.
When you listen to the
Yes,
tape?
it appears to be.
Okay. State would offer States Exhibit 2-60 and 2-61T.
He indicated he's reviewed it. Certainly we could ask questions if he needs his recollection refreshed. Then I think we could move to admit at that point. But if the state would just ask
The state's submitting it as evidence of defendant's words and statements in the relevant time frame.
I misunderstood. No objection.
And so, okay.
We'd ask permission to publish it then if it's offered and admitted.
So 2-60 is the audio recording, correct?
Correct.
And 2-61T is the transcript.
Correct, Your Honor.
Okay. Those two are admitted. Scott, give me just a moment here, sir.
you know, for fair use, we have to stop every once in a while. But you know what? I'm trying to find my Kick channel because I noticed that I attached my Kick channel and I am live on this Kick channel. But when I go over to Kick to try to find it, I don't see it anywhere. So I need to figure that out. Maybe I should go live on Kick sometime. I don't know. I forgot I actually had Kick until today. But so because when you see this right here, that is actually my Kick channel, that little red 0GR86. That is my Kick channel. So, yeah, we're just watching Corey Richards while we try to see if they will just come on and go live over at Texas Supreme Court, which they still have not done, which is so shocking. But anyway, here we go. We'll just keep watching. Thanks, guys.
Give that a try.
Okay. I'm going to ask you to listen to this. It's about 9 minutes long, and then I will ask you 3 questions regarding it. Okay, thank you.
I know I'm live right now. So I don't
Can
understand.
we advance it
That's
30
strange.
seconds?
Thank you
The
so
first
much.
30 seconds is
Okay, sorry about that. I'm going to come to you right now, okay? Thank you so much. Thank you so much.
I'm going to go out and go back in over there, Kick, and see if I can fix that.
I'm not hearing it.
Did we lose it, Scott?
I think so.
All right, no problem. Let's start over. We're getting quicker at this. Scott, if you would disconnect and reconnect on your end, I'll do the same on mine.
I'm going to come to you right now, okay? Thank you so much. Thank you so much.
Code in there. That'd be interesting.
Hey, this is Corey Richards. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of you?
I do. Yeah, I got the file here.
Scott, did we drop that again?
Yes.
All right, I apologize, folks. Let's try that again.
Let's see if this works. Let's log in.
Scott, if you would disconnect from the system, thank you. Then reconnect, please.
If we do any additional microscope.
Okay, let's see if this works. So I try to log into it. What?
I'm going to come to you right now. So much. Thank you so much.
Is that Kristen?
Hey, this
Oh, I
is
can do it
Corey
right.
Richards. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have
These
it in
work.
front of you?
Oh, let me get a code.
I do. Yeah, I got the file here.
So
Yes,
can
so
you,
it
So, you know,
is
so we issue supplemental reports,
7-7.
once the original report's issued, if we do any additional testing, if we do any additional microscopic examination, anything like that, then we include that. You know, we issue a supplemental report to include that additional information. And sometimes it does change the cause or manner, but in this case, it's
okay, it was just like extra testing done?
extra tox testing, yeah. So originally the testing, the only toxicology testing that was done was on blood.
So I'm in my Kick channel. Let's see if it's live over there, guys. I forgot I even had this.
Okay, and so is there a difference in that, I guess?
Well, they just tell you different things in the sense of, it tells you something about what, was it, Has it been there a long time? Is this something the person's been using
That's
for a long
offline, but I
time?
know it's, but I know I'm live over there, so that's kind of weird, but okay.
Injected, is it, whatever, and there's different things you can learn by looking at different substances. I mean, we
All right.
fully expected to find it in the stomach. It's just a question of what was there, so.
So does does this tell you like if it was like injected, if he ate it, is that what this, can you tell from this report?
Not definitively. I mean, it seems like, with what the amount that's there, that it probably was ingested. Probably taken by mouth.
Okay, and so the 15 ng, like, is that like a substantial amment? Is that like a trace?
No, I would have my attorney do the calling. I would not be doing this myself. I think that's dangerous on her part. She'll look guilty.
Okay, so that's quite a bit.
Mm-hmm.
So what's the next one down, the norfentanyl? What is
that?
Fentanyl. It's what your body changes fentanyl into after you take it.
Oh, I gotcha. Okay.
Doesn't she sound guilty?
Sorry, just the third one, the acetyl. I don't know how you say that.
Acetyl fentanyl.
Oh.
Yeah, that's just it's a form of, it's a variant of fentanyl that is usually only present in the setting of illicitly manufactured fentanyl.
All right.
Illicit manufactured, like a pharmacy?
No. He means like not pharmaceutical. Okay, Corey Richens, not pharmaceutical, which means we know you bought it off the streets or something. Anyway, so yes, even right now, the Texas Supreme Court is not live yet. They're still not live. So we've been on almost 2 hours. I've not shown you what I promised to show you. We're just over here watching Corey Richens. So I think what I'm going to do is we're going to get off of YouTube. I'm going to switch over to Kick. And we're going to try Kick for a little bit while we wait on Texas Supreme Court to go live. So why don't y'all bounce that over to Kick with me? So let me give you my Kick screen name so you'll have it, so you can just kind of go over there. I don't know if I can share it from here to there. So let me try it. It is actually 0 R. This is my Kick name, okay? Here's my Kick name. So if you want to go over to Kick, let me see what happens. Let me show you this right here. So this is actually my Kick right there. Well, that's not right. Look, it looks different. Let me try it this way. I think I did it wrong. 0 GR86. There it is. I think it's that one. Let me see if that looks right. Let me see if it matches when I put it on over here. More red, 0 GR8. So why is that big like that? I don't know if that's the same. Let me see. Let me check it over here, and we'll put my Kick name in there. We'll just all go on over to Kick. So it looks like it is LI. It's not. That's not right, guys. Hang on a second. Kick. I'm looking right at it online. LIR. Little red, and then 0 GR86. That is my Kick name. Right there. Okay, so we're going to go over to Kick right now. I'm going to go over to Kick right now and see if we can live stream from Kick. We might as well. I mean, Texas Supreme Court is not live yet. I'm not giving you what I promised to give you this morning, and I feel bad about that because you've been so kind to wait 2 hours with me to not hear Texas Supreme Court yet. So I will see y'all in a little bit. I'm going over to Kick. I'm going to try to live stream over there. Thank you all for coming in. I always appreciate your time. I know you could be anywhere else but here. I just love seeing my friends come into my chat to just, talk with me. So let's go to Kick right now. Thank you guys. Have a good afternoon. If you don't make it to Kick with me, have a good afternoon, and I'll talk to you later. Thank you again. Hey, go hug your babies. That's so important. Life is short and your time with them is even shorter. So I'm going to get off of here and go to Kick. Thanks, guys. Thank you so much.